The Supreme Court, by a narrow 3-2 majority decision, has dismissed an application seeking to halt the ongoing process to remove Chief Justice Gertrude Torkornoo and revoke her suspension. The motion was filed by Old Tafo MP Vincent Eko Asifua and argued in court by attorney Godfred Yeboah-Dame. ChannelOne News' Hansen Ajuman has more.
Acting Chief Justice Paul Bafuboni, along with Justices Yoni Kulendi and Amadou Tanko, voted to dismiss the application. Justices Professor Henrietta Mensah-Bonsu and NSGO dissented. The court has scheduled May 21 for the release of the full ruling. Before this ruling, the same panel dismissed two objections raised by Godfred Dame, one calling for the recusal of the acting Chief Justice and another challenging the reconstitution of the regional panel that began hearing the case. Mr. Dame argued that Justice Bafuboni, as acting Chief Justice, could benefit from the case outcome and should step aside. He also questioned the reconstitution of the initial panel, which had included Justice Samuel Asiedu, NSGO, Richard Ejeyi Frimpong, Yawasari Daku, and was chaired by Justice Henrietta Mensah-Bonsu. The current panel includes Justices Kulendi, Tanko, Mensah-Bonsu, Gewu, and is presided over by Justice Bafuboni. Mr. Dame cited Article 1573 of the 1992 Constitution, claiming that once a hearing begins, the panel cannot be changed until the matter is concluded. But the court dismissed this argument, affirming that under Article 144 Clause 6 of the 1992 Constitution, the acting Chief Justice has full powers of a substantive Chief Justice, including the authority to constitute or reconstitute panels. The objection to the reconstitution was similarly dismissed, with the court ruling that the constitutional provisions cited did not apply in this instance.
The process will go on. The process will go on. The committee would sit, they would hear the inquiry into the matter. And of course, I have always maintained that the finding of prima facie case is not automatic that the Chief Justice or the person who is being, who is the subject matter of the petition has been removed. It is not at all. So it may come out that the Chief Justice, the petition has not been of merit, and the Chief Justice will be restored to her position.
The reasons for the decision have not been known. Of course, clearly, the spirit of Article 146 we're talking about. In the first place, it is important to indicate that nowhere in Article 146 will you find a requirement for prima facie determination made for a Chief Justice. But the Supreme Court itself imported that into Article 146 in 2005 when it adjudicated on the Adjustment matter. But of course, the Supreme Court was silent on whether there ought to be notification to the Chief Justice and obtaining of his requirement before triggering the process. And that is what is in this week before the court.